Welcome, everyone. I'm Kara Griffith, the President and CEO of Tax Analysts. Thank you for joining us today to discuss the Third Circuit's opinion in Culp versus Commissioner, a case that may enable taxpayers to get the tax court to take a late petition, and that may start a trend that other circuits will follow. Today's event is another in Tax Analysts' series of public discussions that we call Taxing Issues. We launched this series as another way for tax analysts to encourage debate on tax issues. We have been bringing the tax community together with leading policymakers and experts for bipartisan discussions on the future of tax policy and administration. As always, we welcome your feedback on how we can make our webinars more useful, as well as your suggestions on future webinar topics. You can send your feedback and suggestions to events@taxanalyst.org. We also welcome your questions for today's event. Please use the chat feature to submit questions during the webinar. For our panel discussion, I'll begin by asking a few questions, and then we'll turn to questions from you, our audience, and I promise to get to as many as time permits. For those of you that would like CPE credit today, please be sure you participate in the program for at least 50 minutes and answer at least 3 of the poll questions that will appear throughout the webinar. They will appear on the right side of the viewing window above the comment section. To receive credit for your answers, you need to register with Pigeonhole, our interactive Q&A system, by providing your name and email. Also, please remember to remain in the default viewing window because you won't be able to see the questions if you expand the program to full screen. The course materials, which were sent out in advance, are also available for downloading under the viewing window. Now, before we jump into today's topic, I have an exciting announcement. Tax Analysts recently added the blog known as Procedurally Taxing to the Tax Note suite of federal products. It was started in 2013 by Leslie Book, Keith Fogg, and Stephen Olson, and it grew out of their experience working with, writing about, and teaching tax procedure. The Procedurally Taxing blog also shines a light on procedural issues that affect underrepresented taxpayers. For those of you who don't know them, and I hope that's no one, let me quickly introduce them. Leslie Book is a law professor at the Villanova University School of Law and a senior fellow at the Center for Taxpayer Rights. Keith Fogg is an emeritus clinical professor of law at Harvard Law School. And Stephen Olson is faculty director of the graduate tax program and a professor of practice at the Villanova University School of Law. He's also a partner at Gothrop Greenwood. We are thrilled to bring Procedurally Taxing into the Tax Notes family, along with Les, Keith, and Steve, as well as their many guest contributors. I hope those of you who have been following Procedurally Taxing will continue to do so on taxnotes.com. If you have any trouble finding the blog, please contact your account executive or reach out to our customer service team at customerservice@taxanalyst.org. Now, Les, if I can turn it over to you for just a moment before we jump into Culp and just give us a little bit of history on why you guys started the blog, when you started it, and its purpose and mission.
Sure. Yeah. Thanks, Kara. And it's a pleasure to be here today and to be part of Tax Analysts and Tax Notes as well. And we started the blog about 10 years ago. Keith, Stephen, and I had been working together in a few different capacities, but in primarily our work on the IRS Practice and Procedure Treatise, which was started or originally written by one of my mentors, Michael Saltzman. And we'd been doing a fair bit of work kind of updating and rewriting that treatise, and we're familiar with a lot of developments. And we felt like there was an opportunity to shine a light on some of those developments and focus them to the community at large, and to also kind of consider some of those issues as they related to broader issues of tax administration. And in particular, as you noted in your introduction, Kara, we all have had experience working with low-income taxpayers. Both Keith and I have been directors of tax clinics, and Stephen was formerly working at the Villanova Tax Clinic as well, and had done a fair bit of work in practice as well and engaged in those issues. So we wanted to take an opportunity to write about those issues and not just kind of list them, but provide context and analysis with the hope of trying to really informed discussion and hopefully improve issues of tax administration. Frankly, a lot of issues that relate to lower income taxpayers came up through unrepresented or pro se taxpayers, and a lot of times those issues were sort of a little bit out of the in the shadows. And we felt like it was an opportunity to not only talk about issues of tax procedure generally, but also to bring in attention on issues that related to underrepresented taxpayers. And it just so happens that as we were talking about and preparing for today, we're going to be talking a lot about the Culp case, which is a really interesting case. And we went back and looked at our blog, and we started writing about the issues of jurisdictional issues and deadlines back in 2014. In fact, one of our guest contributors, Carl Smith, wrote a blog post about a case that was known as the Volpicelli case, where he talked about the potential for changes in the way that tax deadlines were viewed in light of Supreme Court precedent. We're changing in Supreme Court precedent from the early 21st century, a case called Contract versus Ryan. And interestingly enough, the first time Carl wrote about that was in a tax notes article in 2012. And so we've been blogging about those kinds of issues and writing about those kinds of issues for a long time. And the blog really provides an opportunity for us to shine a light on those cases and those types of issues, which we think are really important for tax administration.
Thanks so much. And they are important. And this is, for tax notes, this really helps us with some increased coverage. So we're very excited to have the procedurally taxing team, as well as all of the content to sort of bring extra light to some issues that we might not necessarily have covered. So, and it does bring it full circle since you guys started, and one of the first articles was from Tax Notes. So let's turn and do a little bit of background on Culp. I'll do very high level, and then I'm going to turn it over to you three as really the experts to dig into the nuance. What does this mean for taxpayers? And then a couple of tangential issues as well. So Culp. Culp called into question the 90-day deadline for taxpayers to file a petition after they received a notice of deficiency. In Culp, the taxpayers didn't file a petition until nearly 3 years after the IRS had issued their notice of deficiency. Although the tax court dismissed Culp's case due to lack of jurisdiction, the Third Circuit ruled that the 90-day deadline wasn't jurisdictional and is only directed at the taxpayer. In other words, even if the taxpayer didn't file a petition within 90 days, the tax court can still have jurisdiction over the underlying issue. In addition, the Third Circuit found that equitable tolling, which pauses the running of a statute of limitations, can apply to the deadline. Now, the Third Circuit relied on a 2022 Supreme Court decision that held that the 30-day deadline to file a petition to the tax court to challenge a notice of determination under Section 6330 is only directed at the taxpayer and doesn't govern the tax court's jurisdiction. Now, Culp is currently on a petition for rehearing, but at the moment, it creates a split among circuits over whether the Section 6213A deadline is jurisdictional. This is a really interesting win for taxpayers. But still, the tax court seems to hold the view that the 90-day deadline is a hard and fast rule. And in several cases, the tax court has reaffirmed its opinion that outside of the Third Circuit, that 90-day deadline is jurisdictional. Now, that opinion is likely to be challenged in other circuits, and perhaps the Supreme Court might take this up if we have a split for too long. So there's a lot more to this case, a lot more beyond my brief overview. So to kick it off, Steve, could you fill in some of the other background points and other important details that there are about the Culp case?
Yeah, thanks so much, Kara. And I just want to echo Les's sentiments about procedurally taxing coming to Tax Notes. We're so excited about being part of the family, and thanks for having us on today. I'm going to try to set this up pretty briefly. I feel like I'm sort of standing in the way of the main attraction, which is really Keith talking about this case and the impacts. He's been so influential in what's happened, and a lot of what I'm going to be highlighting is really talking about what Keith actually did and what he's going to cause to have happen in the future. And so I'll go through a lot of the background, but once we get to the actual holding in the Third Circuit, I'll probably push it over to him to discuss the case. So going way back, we all know that there's lots of rules stating when a taxpayer who has some sort of grievance has to petition the tax court for review. For instance, once a determination's been made in a collection due process hearing, taxpayer has 30 days to petition the tax court for review under Section 6330D of the code, like you indicated, Kara. And also when the service determines there's a deficiency of income or estate tax, Notice of deficiency has to be sent to the taxpayers initially, and then after that, a 90-day letter is issued under Section 6213A of the code to the taxpayer. And as that name would suggest, it gives the taxpayers 90 days to petition the tax court for review of that deficiency. There's other similar deadlines in other areas of the tax code, including whistleblower claims. And historically, if you failed to meet these deadlines, the government would move to have the case dismissed, arguing that the tax court lacked jurisdiction due to the late filing. And if the government failed to do this, a lot of the time, the tax court would actually sua sponte raise the issue and have the case dismissed on its own. I think Carlton Smith, Procedurally Taxing's good friend and frequent contributor, found that the tax court was doing this potentially up to 200 times a year, so not an insignificant number of cases. And just to reiterate some of what Les was saying, Carlton Smith in many ways is the architect of a lot of the arguments that we're going to be talking about today with Keith. And I suspect Keith will probably have some insights into that too as he talks about these cases. So there have been these arguments for 15 years that the judicial filing deadlines are not jurisdictional, and instead they're like claim filing rules. And outside of the tax law, courts have held that this is the case for about the last 20 years. And why this is important is that you can't equitably toll a jurisdictional rule, but you can claim that with a claim filing type of rule. And equitable tolling would allow a taxpayer to file after the stated deadline if they had a good excuse for failing to actually be able to comply with the time frame for the petition. So for years, Keith and Carlton Smith have been at the forefront of these arguments, advancing through the tax clinic at Harvard. And this is a great issue for us to be talking about, as Les mentioned, with the blog, because we've had something like 95 blog posts on this, and we have used it to help kind of gain some momentum. And I think Keith could fill in more on this, but I think we've received good feedback from lots of people in the practitioner community to help kind of fine tune those legal arguments. And again, that's something that we like to use with the blog to try to push these things forward. Another similar area where we saw a lot of this was in 6751 and supervisory approval of penalties and the nightmare that came about after all that. We were sort of at the forefront pushing those arguments really early on in the blog. And it's really cool to get to see these things on the blog as we work through these ideas in our writing and then see them make it into a brief and then eventually into actual case law, right? And that's what happened here with the equitable tolling and tax deadlines. Keith and others began to have some success with these arguments. Myers was a whistleblower case with a filing deadline under 7623, I think, which the DC Circuit held was not jurisdictional and could be subject to equitable tolling. That was in 2019. The language in Section 7623 is very similar to the CDP language, and some CDP cases started to have some wins, and eventually leading to, I'm going to mispronounce it now, Beckler v. Commissioner going to the Supreme Court. And in Beckler, the Supreme Court held that the filing deadline was not jurisdictional in CDP cases. There was no clear statutory language indicating an intent for it to be jurisdictional. And the Supreme Court also held that it was subject to equitable tolling, assuming the right facts were present. So this was, again, indicated because the statute had no clear intent for there not to be equitable tolling. And the case law at the common law creates a presumption towards allowing equitable tolling in these type of filing deadlines. So this was around 2022, and Carrie, you kind of mentioned Hallmark Research Collective was decided by the tax court around that same time, and that held that the 90 days for a deficiency case petition to be brought was in fact jurisdictional. After Beckler came out, the court was asked to review that again. The court declined and then continued to hold that in the deficiency proceeding context, that 90 days was jurisdictional, unlike what we saw in the whistleblower cases and the CDP context. So this kind of brings us to the Culps. The Culps received a lawsuit settlement in 2015, I believe, reported on their tax returns. Subsequently, the IRS erroneously determined it was not included on their tax returns. The IRS sent the Culps a 30-day letter indicating there was a deficiency, and then sent them a 90-day letter giving them 90 days to petition the tax court for review of the assessment. The Culps failed to petition that in a timely manner. And the next year, I think the Culps received a levy notice indicating there was going to be an attempt to collect the tax due. And subsequent to that, the Culps then petitioned the tax court for review of the deficiency. And then, Kara, as you indicated, right, the tax court held that the petition was untimely under Section 6213A of the code. and dismissed it for lack of jurisdiction, even though we have these other cases in similar contexts indicating it wasn't a jurisdictional statute. This case was appealable and was appealed to the Third Circuit, and that's probably a good time to turn it over to somebody who had some direct knowledge and involvement in that case. Perhaps Keith could outline what happened on that appeal.
Okay, thank you, Steve. Well, the Harvard Tax Clinic came in as an amicus in the Culp case. We were not representing the Culps, and we are still not representing the Culps. But we filed an amicus brief to argue that there is no jurisdictional bar to filing a deficiency case late, just as the Supreme Court had determined there was no jurisdictional bar to filing a CDP case late. Kind of to go back before you get to the Culps, kind of plow over ground that you guys have talked about a little bit, but Culp and Smith really brought up this idea going back to the Bocelli case and the articles that he wrote. But when I started the Harvard clinic in 2015, Carl came as a volunteer in my clinic, and he said we should be looking for cases with this issue, and we pretty quickly found one by the name of Goralnik that we argued as an amicus in 2016, and the tax court told us 17-0 that the time period for filing a CDP case was jurisdictional. So that began for us a series of losses in circuit courts around the country. So while we think about Culp and Beckler as big victories, most of the time we've been losing because we've always lost in the tax court, and we've lost in most of the circuits where we've made these arguments. But we persisted. So we argued it several times, and eventually, as Steve mentioned, the Myers case was decided in the DC circuit, and that created the circuit split that allowed Beckler to go to the Supreme Court. After the Beckler case was decided, we began arguing with respect to deficiency cases. And the first one that we found was the Culp case, which was actually dismissed by the tax court shortly before Beckler was decided. Once Beckler was decided, the tax court actually put all of the late file deficiency cases on hold, waiting for them to think about how Beckler would impact the deficiency jurisdiction. And then, as Steve mentioned, in the Hallmark case, they decided again 17-0 that the Beckler case didn't have any impact on whether the deficiency jurisdiction was impacted. So, the reason that they did that is that you have to look at each statute. You're looking at each statute that's a grant of jurisdiction to the tax court or to any court to see if Congress made a clear statement that the time period was a time period that must be met in order for the person to get into court. And what's been alluded to, about 20 years ago, the Supreme Court said, well, we've not been very clear about the way we've discussed jurisdiction. In the Country versus Ryan case that Les mentioned, they said we want to change the way courts look at this, and we want to only be dismissal if there's a clear statement in the statute. And absent a clear statement, then the court still has power to hear the case. That doesn't mean they will hear it, because you have to get into equitable tolling, but that power issue is what the Supreme Court started talking about almost 20 years ago. So there's a whole line of cases, almost every year, every other year, the Supreme Court has looked at another case involving the jurisdiction, because the tax court is not the only court that's saying, well, wait a minute, we have, in the tax court case, we have 99 years of history here where it's jurisdictional. Other courts were saying, well, we have 20 years or 50 years. All the courts were struggling as the Supreme Court group of opinions came out. And so when we began litigating this in the tax court was just another one of the courts struggling to absorb what the Supreme Court was saying about jurisdiction, and having difficulty because they had all this history. So when the Culp case came to our attention, what we've been doing for the last almost 7 years is looking at the cases as they come out of the tax court where the court denies jurisdiction, to see if the case is one that's a good case to make an argument. And in the Culp case, we really were beyond that point because they had already filed the appeal when the case came to our attention. So when that case came to our attention, we reached out to the Culps and asked them if they wanted assistance in the form of, an amicus, and they were open to that. And we assisted them in some of their brief writing because we had banks of briefs that we've been writing for several years. And we argued that the jurisdiction for deficiency, there was no clear statement, and therefore the tax court could hear a late file case because the statute wasn't jurisdictional. Then we argued that once you get over the jurisdictional hurdle, we argued that the court had the ability to determine through equitable tolling that the taxpayers could come in. So that case went to oral argument last March in Philadelphia in the Third Circuit, and the court was interestingly nice enough to invite the Harvard Clinic as amicus to participate in oral argument. And because of the timing and the director's unavailability that day, I ended up being the person to make the oral argument together with a former student of mine, Oliver Roberts, who came in as the attorney for the Culps. So we argued that the statute was not jurisdictional and argued that the court should grant equitable tolling. And the court, looked at both issues. It looked at whether there was a clear statement in the statute and found there was not. The court looked at whether there was a prior Supreme Court decisional law that controlled and found that there was not. And so based on those two findings, it determined that the time period for filing a petition in the tax court was not a jurisdictional time period. And then it had to move to the second step because the government also argued that even if it's not jurisdictional, the statute didn't permit equitable tolling. And in that argument, they were looking at a Supreme Court decision regarding refund cases that came out in the mid-1990s, and a case that the government cites to in every one of these cases. And the court, looked at that case and looked at the general rule is that you default to equitable tolling, and the court determined that there was no reason not to follow the general rule in this case because the time for filing a petition was relatively short. 80% of the people who file in tax court are filing pro se, so the group of people that the statute is impacting is a group of people who needs help. And the other factors the court looked at in determining that this was a statute in which there should be equitable tolling. But once the Third Circuit reached a rather straightforward opinion on that, which seems logical, but yet is going against 99 years of history on tax court deficiency cases, the government requested that the Third Circuit relook at the case en banc, and so that's the posture of the case right now. The government has requested an en banc rehearing of the Culp case. The court has taken in statements from the taxpayer and from amicus, and is in the process of deciding whether to grant an en banc rehearing of the decision. If it decides to grant that hearing, then it'll take place in the next few months probably. If it decides not to grant the en banc rehearing, then I wouldn't be surprised if the government sought cert in this case because of the clear split and the desire to get clarity for the tax court and what to do, because it puts the tax court in a bit of an awkward position to have one circuit where people can file and come in late, and then all the other circuits where the tax court is going to dismiss them for lack of jurisdiction. So that's where we are with the Culp case in a nutshell. I don't know, Kara, if you have questions you want to follow up with on how the posture is.
Well, I definitely do have some follow-up questions, but I just to sort of keep us going in a somewhat logical fashion, I want to turn to Les to talk about what are the other cases that are out there. I think it's a very good point that the government is going to want some clarity for the tax court because we do have some other cases that are sitting out there right now, and then it becomes very difficult to say, well, if you're in the Third Circuit, you've got the option of having a late petition, but if you're in the Second Circuit, sorry, yeah. So Les, could you give us a little bit of a background on what other cases we have out there? What does that landscape look like? And then we'll dive back into Culp.
Yeah, so there are issues that are directly related to to this 90-day deadline, right? So there's a question in terms of whether, there are very few circuits that have had a full-throated discussion of the issue as to whether the 90-day notice is 90-day deadline is jurisdictional. So right now we're kind of in a state of flux, and I know that there's an active case now in the Second Circuit, which has the same issue teed up, and Keith is directly involved with that as well. I know Keith will speak to that. But in addition to those kind of the issues around the 90-day deadline, there are also kind of issues that, as Stephen noted, involve other deadlines. So there was just a case recently, the organic cannabis case, which we had a blog post on, I think, in the last week, that looked at the deadline in the context of submitting a CDP request for a hearing, and looked at that and basically overruled prior cases which had held that 30-day deadline was jurisdictional. And so that, there are cases that are there are so many deadlines in the IRC, and this is now becoming an issue that is forcing taxpayers and courts to think of these issues kind of anew. So that's why the case has such broad significance, beyond, not to say that the 90-day deadline itself isn't significant. That has its independent significance, but this kind of really is one of broader import. And it goes to kind of the point of some of the things that Keith mentioned as well. So many of the cases that came out post the Brokamp case, which is the Supreme Court case in the 1990s that concluded that the refund statute 6511 is jurisdictional, not subject to tolling. So many of the cases that came out after that were that considered other deadlines were pro se taxpayers, were involved taxpayers who were not represented. And what we're seeing now with clinics like Harvard and Villanova's and other clinics, and the Center for Taxpayer Rights, which has been involved as a client in some of these cases, there's really an opportunity to have a full-throated discussion of the underlying merits of these cases in a way that was not really, being able to have been done. So that's one of the positive kind of outshoots, not only of the blog, which highlights these issues, but just around tax administration more generally, where there is kind of a more engaged public interest community, both pro bono lawyers at large law firms, but also folks working at clinics. So that gives a little bit of the context, but I think as we can discuss, there are a lot of specific cases that involve the particular 90-day deadline. I know the Second Circuit has a case that's being teed up right now.
So Keith, let's jump to that, since Les teed us up for that really well, to turn to the Foley case, which is in the Second Circuit. I know that you are active in that case, but perhaps you could give us a little bit of of background on what it is, and then Les and Steve, maybe you can follow up with some of the importance thereof.
Yeah, the Foley case raises the same issue as Culp, of whether the 90-day period for filing petition is jurisdictional. So it raises it in a different circuit, giving the opportunity for there to be a split. As Les kind of mentioned, there haven't been cases that have really looked at this jurisdictional issue since the Supreme Court started changing the law 20 years ago. There's 2 tax court cases on the deficiency issue that have looked at it, but those were both pre-Beckler as well. And a lot of the both the Ninth Circuit and the Seventh Circuit determined that looking at post-contract decisional law that the deficiency time period was jurisdictional, but the reasons that they gave in those cases were kind of knocked out by Beckler. So this Culp is the first post-Beckler case, and that makes a difference. So there needs to be more, unless Culp goes to the Supreme Court and takes care of it very quickly, there will be more circuit court cases coming up looking at the deficiency jurisdiction and through a post-Beckler lens. And Foley in the Second Circuit provides that opportunity. But what's a little bit different about Foley, and so before you get to the jurisdictional issue, about half of the cases filed in the tax court are filed as small tax cases. And that's what Mr. Foley did. He filed his case. He made the election to have his case treated as a small tax case. Small tax cases cannot be appealed But the issue is, can you not appeal the outcome of a small tax case? Certainly, I mean, if the court went to the point of decision, that would be the right result, that you'd be denied from the ability to appeal. But can you appeal the dismissal of a case for lack of jurisdiction? Can you even make an S case, a small case election, if the court never had jurisdiction over your case? So right now, the Foley case is in a preliminary fight to determine whether somebody who elected small tax case status in the tax court can appeal this jurisdictional dismissal. And when we're talking about these cases, most of the cases where the tax court dismisses someone for lack of jurisdiction, and that happens in deficiency cases about 600 times a year based on our research. But most of those people who get dismissed are pro se, and I would say half or more than half are choosing the small tax case election. So it's not a small issue. That there's no precedential decision really on small tax cases and whether you can appeal a jurisdictional dismissal. So that issue is teed up in Foley as a predicate issue to the issue of jurisdiction. So I think if Mr. Foley is able to get past this predicate issue, then I think the Second Circuit will be presented with essentially the same arguments that were presented to the Third Circuit. And there are other cases around the country that are percolating. We watch every dismissal from the tax court, and we reach out to people and we hear from people. But to my knowledge, there's not another one that's teed up in a circuit court right now. And I'm not sure when Foley will when or if it will move forward to get to the jurisdictional issue, and waiting for the Second Circuit to decide on whether a small tax case, someone electing the small tax case, can go forward with an appeal of the dismissal.
Yep. And one point I just want to highlight, if I may, Keith mentioned the work that was done back in the Groundlick case, and I think it was a 17-0 taxpayer loss, and those are stinging. Those can be hurtful when things don't go your way in that fashion. One of the things that's really interesting about the Culp issue and the broader issue is the relationship between tax administration, tax procedure, and other areas of the law, which are not on their face directly. You wouldn't think they're necessarily directly related to tax issues. But one of the things we've seen, and one of the things we've blogged about continuously, is trying to be cognizant of issues outside tax that should or are having an impact on issues of tax procedure and tax administration. So, we're very much in tune, or try to be in tune, either ourselves or working with commentators or practitioners or other academics who, for example, who are writing on broader issues of administrative law, which is, as we know, has become such importance in tax litigation in the last decade. So this is really, while when you look at the history in tax cases, how tough this issue has been, right, and the fact that there was a 17-0 defeat initially, well, when you think about this from a broader perspective, I think the odds of success or the opportunity for like litigating these issues presents itself in a way that maybe kind of a narrow tax view maybe loses sight of. So we've tried to, in our blog, kind of broaden the lens a bit and bring out those issues which we think should have importance as you kind of litigate in forms that may not necessarily be as well versed or thinking about those non-tax issues.
I think that's a fantastic point, and it really also highlights the good work and the important work that a lot of the clinics around the country are doing, because when you've got some of these issues, we really are talking about those that are underrepresented, those that are or simply don't have representation at all. And I wanted to get your thoughts. You've all worked in or with or around clinics over the years. How has the role of the tax clinic changed over the years, and why is that important for tax administration?
Yeah, I'll jump in first, since my time in the clinic was probably the furthest away of everyone's and the least extensive. But when I was going through the clinic, Les was actually the professor in charge of the clinic at the time. And we were trying to assist taxpayers on specific issues at that point, but we weren't thinking about how to use it more proactively to change the law and move things in a different direction, which seems to be what Keith and others are doing a lot more now.
Yeah, I mean, it's interesting, and Keith has written a lot about, Keith has written a tremendous article on the history of clinics, and so he has a lot of, spent a lot of time thinking about this. But I know when I first started in the clinic many moons ago, right around when the Restructuring Act was passed, I thought about how there was little attention given to issues that lower income taxpayers or underrepresented taxpayers kind of faced. And so my initial thought was I tried to do scholarship around those issues. And as Stephen noted, I wasn't really doing impact litigation so much when I started in the clinic. Over time, that's evolved. And Keith and others have really begun kind of the work of doing high impact litigation that I think supplements scholarship, and the scholarship kind of feeds that, and it's kind of a virtuous cycle. So there are people who are now, clinicians and others who are focused on those issues, both from an academic and from a writing perspective, but also from an advocacy perspective. And that really is important because, as Keith noted, so many tax cases involve pro se or unrepresented taxpayers. And while judges have good faith and want to get to the right answer, sometimes you just miss something if it's not zealously represented, or the taxpayer is not competently able to express their positions in a way that maybe an advocate or a scholar can present.
I think it's also worth noting how difficult it is for many clinicians to have the time or the background to bring impact litigation. So I think we're still at the beginning stages of clinics being real impactful, but part of that is that a lot of clinicians are basically solo practitioners, and a lot of them didn't do tax before they became tax clinicians. So there's a huge difference in the makeup of tax clinicians, and that difference kind of drives what those clinics are able to do. So I was very fortunate at the Harvard clinic. I had a volunteer like Carl, and I had a lot of resources given to me by Harvard that allowed me to pursue impact litigation. But a lot of clinics just don't have the background or the resources to be able to do that. But I think more and more, and particularly the academic clinics, are beginning to do this. And it's not only litigation. Where I think there's been another big change in clinics is the desire and the ability to comment on regulations and on rules, and that can have an even bigger impact than litigation. So at the Harvard Clinic, we tried to comment on every regulation that we thought had an impact on low-income taxpayers, and we commented on every time the tax court put out rules to comment how we thought they would impact low-income taxpayers. And other clinics are doing that as well, and particularly there's been a big boost from the American Bar Association and the tax clinic committee there. So there's a lot of, and the scholarship that Les is talking about, more and more clinicians who are academics are producing scholarship that reflects on issues that impact low-income taxpayers. So I think that in the 25 years since the Restructuring and Reform Act came out, and the clinics were given money to be created, there's been a huge change over that 25 years as clinics have grown, and I expect that over the next 25 years they'll continue to grow.
Yeah, and also it's worth mentioning the Center for Taxpayer Rights, which is an is the organization that Nina Olson, following her career at our time at NTA, founded, and Keith and I are involved in that. We're on the board. And it's put together a resource center for clinics to assist in working on technical issues, but also to help kind of focus perhaps on impact litigation as well, as Keith mentions. So things are developing in a way that one might expect, given the importance of the tax system overall to all sorts of policy issues, and so I think it's a welcome development. And as Keith noted, and as Steve noted, things are moving. It's a progression. I think things are going in the right direction.
And I will also note that if any of our viewers are with a low-income taxpayer clinic and they want access to tax notes, for purposes of perhaps keeping track of the Procedurally Taxing blog, please reach out, because we give complimentary access to tax notes to all of the low-income taxpayer clinics. And so if there's a way that tax analysts can serve the clinics, we'd love to be a part of it. I want to ask a couple questions on Culp, and then I've got a couple of tax administration questions if we get that far. But to turn back to Culp for a second, I wanted to gauge your thoughts on if a split continues, is this the type of a fact pattern and the right case for the Supreme Court to take up? So Keith, maybe I'll start with you on that, since you're probably the most intimately involved. What's your prediction on Culp going all the way to the Supreme Court?
I think there's a very good chance that it will. I think the government will push. I mean, assuming that the Third Circuit doesn't change its mind through the rehearing process, I think the government will push the issue toward the Supreme Court. I can't say that whether I know whether the Supreme Court would accept it or not, but there certainly would be a split among circuits. So I think it's possible this case that the Culp case itself could wind up in the Supreme Court. I know, talking with my colleague Carl Smith, that's definitely what he expects. Maybe I'm a little more reserved than Carl is, but I think there's a high likelihood that Culp will end up in the Supreme Court.
I think everybody would want that result, right? If the split continues, the tax court wants that result, the government wants that result, the practitioners should want the result. And I guess I probably lean a little bit more towards Carlton too, because just there could be a number of these every year that keep coming up and keep having that split. It's not just a one-off issue.
Yeah, I mean, I think that in this instance and in so many others, everyone wants the certainty of knowing. We want to know the rules by which we're playing. So I guess I would hope that if the split continues, that there would be a case that the Supreme Court would take and provide guidance on that. It will be interesting to watch. In Culp, I thought it was very interesting because, Keith, the Harvard Law Clinic came in as an amicus, and we're seeing more and more of these pro se cases where the tax court is actually seeking out amicus. And I wanted to get your thoughts on that, on the benefits that amicus can provide to pro se taxpayers, and also can provide across the board, and how does that help tax administration? I'll open that up to all three of you.
I wrote an article on this with one of my students at Harvard a couple of years ago that was published in the Houston Business and Tax Journal, arguing that the tax court should affirmatively seek amicus in any pro se case in which it was going to issue a precedential opinion. We looked at all the precedential opinions since 1969 that had been issued, and particularly and then focused in on the precedential opinions that were issued in cases where the taxpayers were pro se. Not because we thought the tax court had any desire other than to find the right answer, but because it becomes so much harder for the court if they are just if they just get a brief from the government and don't get a brief or don't get a meaningful brief from the taxpayer. And I was very encouraged that the tax court, shortly after we put the article out there, proposed a new rule with respect to amicus briefs. It previously didn't have a rule on amicus briefs, and that rule doesn't quite say the same thing that we were arguing for in our article. But the rule now creates before the rule that you could still file an amicus brief. That's what we did in Goralnik back in 2016. But now there's a formal way to file an amicus brief, and some of the judges have reached out in their precedential cases with pro se taxpayers. And so I think that the tax court is very much thinking about this. And I think it not only will benefit the taxpayers, but it certainly could benefit the court and benefit tax administration as a whole. Because if you have a pro se litigant in a case that becomes precedential, you sort of lock in an opinion that impacts everybody, not just pro se taxpayers, but represented taxpayers, big taxpayers, little taxpayers, and then you have to fight to overcome this precedential opinion when the precedent was set without giving it a full-throated adversarial posture in terms of the briefing. So I think that we're moving in a very positive direction with respect to amicus briefs, and that not only is our clinics like Harvard and other tax clinics willing to write amicus briefs, but the American College of Tax Counsel is doing a fair amount of amicus work. A lot of practitioners are doing amicus work. So I think there are plenty of people or organizations that can step up when there's going to be a precedential opinion issued in the tax court, and the tax court wants an amicus brief. So I'm very encouraged.
Yeah, I think it's a tremendous development, because as Keith noted, there's this kind of lock-in effect when there was when there was a precedential opinion that addresses an issue that was not really fully litigated or fully argued in the way that one sees in cases where amicus or maybe more sophisticated taxpayers were involved. And that frankly is one of the real benefits we've thought of the blogs. We were able to highlight some issues that maybe early on that could benefit from input from able counsel and from academics, and that's something that we really have tried to shine a light on. We've also had a lot of blog posts where people have been belly aching after there have been precedential opinions that come out from pro se cases from many years ago. So we're that it creates a real opportunity for discussion and critique. And again, as Keith suggests or Keith states, right, it's not as if that the court wants to to not give it a full hearing initially, but sometimes it's just hard to do that, right, when a matter is not fully briefed. And this just provides the opportunity to get to the right answer more often than not. And I think that most people want that and want to have the issues fully vetted, and that's one of the real positive developments of the amicus rule that Keith mentions.
I think too, and Keith, you saw a bit of this while you were working through the Culp case and prior cases, right? If the pro ses aren't represented, not putting forth a strong case, strong argument, the government is, and the government can decide which of these are actually going to go all the way through, right? If there's going to be a precedential opinion they don't like, they can settle the case and move away from it. If there's not an amicus or someone else they're advocating, it's not, the rules could get slanted towards the government's favor intentionally or unintentionally.
Yeah, that was another question that I wanted to get to at some point was to talk about settlement and the IRS settling cases so that it doesn't have to go to tax court and get a negative opinion. Les, I'm going to start with you on this because I know that you have talked about this before. That's very detrimental to tax administration as a whole, because then when we're not getting the complete picture, we're getting cherry picked. And so I'd love your thoughts on this topic.
Yeah, it's part of the nature of litigation, right? So as Stephen notes and Kara, as your question suggests, the government has a lot of power in these cases. It can, if the facts aren't in its necessarily as sympathetic or for whatever reason, the government can choose to settle a case that may be favorable for the taxpayer in question, but doesn't provide any benefit for other taxpayers. And that's a real, that's just the nature of the adversarial process of litigation. In part, and Stephen wrote a blog post about this in the context of refund litigation recently involving the Jarrett case involving the taxation of cryptocurrency transactions. It's an issue, right? And again, it's a kind of thing which is I think inherent or partially connected to the nature of the way disputes are resolved, and especially when you have a situation where maybe Congress isn't as functional as we'd want it to be, and a lot of times issues that maybe would benefit from a technical correction or legislation, we're not getting that these days. Congress is I guess it's not really in a position or able to kind of give us the kind of certainty around some issues that perhaps could need a legislative fix rather than having litigation and of the kind that we're talking about today in today's session.
Yeah, it's interesting because we don't get a lot of guidance from Congress. It's exceedingly difficult to get a tax bill, even a correction passed through Congress. And that's been one reason. And the founder of Tax Analysts felt so strong about going after the working law of these agencies. So figuring out what are the agencies putting out, which leads me to a question about the tax court. And I know Tax Notes has struggled for many, many years with accessibility to tax court documents. This has been very difficult. It's been frustrating because that is how you figure out what is the court thinking, what is the IRS thinking. Is we try to put together these agency guidance type documents. I would love for your thoughts on how we might see greater accessibility to tax court documents and the importance of it, and also how that would improve tax administration.
I'll take the lead here since I've done the most writing on it. But I wrote a pretty long article in Tax Notes with a student, I think in 2019, sort of laying out how I thought the tax court could make their documents more accessible. But you know, the tax court comes at this, you know, with a very good intention. So they are seeking to protect. They have 80% of the people who are filing there pro se, and those people are putting lots of stuff into the court files that contains unredacted Social Security numbers and other information that, you know, the court, you know, doesn't really want to be the middleman to put out people's personal information. And I certainly understand that. So that you know, you have on the one hand the court trying to protect taxpayers in a way that the PACER system, if you're, you know, for those who are familiar with the PACER system that covers district courts and bankruptcy courts and circuit courts and the Supreme Court, the PACER system doesn't do that. So in PACER, you get a lot of information about taxpayers unfiltered. The tax court is not governed by the PACER system. It has its own basically governance on what it will make public, and it really seeks to protect the privacy of taxpayers. And so the question and what I was writing about and what I've written a number of blog posts on, and the tax court has heard me more than they want to, I'm sure, is I think that the dial is still too far on the side of non-disclosure, that they could disclose more, but they have started opening up. I mean, so the tax court has a really wonderful system of disclosing their own information. So whenever they issue an order, it's publicly available and it's free and it's searchable. And so that's a wonderful system that doesn't exist in PACER. The tax court recently opened up a lot of the briefing to be public, starting in August of this year. I know they're looking at opening up perhaps some other documents. I'd love to see them open up the pretrial memorandums, because that's very important for people who are going to calendar calls. So I know they're thinking about it. They think about it maybe more slowly than I would like, but I appreciate their concern for taxpayers and the information that's in their files. Not only do pro se taxpayers fail to redact, but practitioners fail to redact at a very high rate as well. So. And the court is trying to protect the public from it, or the petitioners from themselves in a way. But I think that when you're talking about briefs, it's not that never would information go in there that you wouldn't want to make public, but it's not very common. Particularly a government brief. The briefs from the government, they're very protective of taxpayer information. So I like to see I like the trend the court is on. It's a slow trend, but it's a good trend. And so I'm hoping that over the next several years, you know, they will find a way to open up more and more. But I do share your frustration, Kara, that it's hard. I mean, I almost know all of the people in the court's record office because I call them so often seeking to get documents from them and to pay them. And the court did change the rules on that shortly after the article that I published in Tax Notes. They reduced the fees, so they're thinking about it, and hopefully they'll continue to think about it, and things will continue to open up a bit. But at the same time, I appreciate that they're thinking about protecting taxpayer information.
But you know, the access to orders and other things through the Dawson through the tax court's changes recently, really help us as writers and bloggers and advocates, right? So it's there are some real positive developments, but as Keith notes, I think we've tried to on the blog be a forum to, as tax notes and tax analysts, in your history, we've looked for more information. We think transparency is an important value. Obviously, taxpayer protections and confidentiality is something that's important. It's finding the right balance can be challenging.
And I will say, undoubtedly, it can. And tax analysts has never been for the disclosure of taxpayer information. In fact, we routinely send documents back that have not been properly redacted, and we have our own system of going through all of our documents to make sure we're stripping out, because it is remarkable how many times the government or a practitioner leaves in confidential taxpayer information that should certainly have been redacted. So there is, without a doubt, a balance to be had. I would love to see more briefs come out of the tax court. I think that would be useful to taxpayers. I think it would be useful to the pro se taxpayers who really, they don't have a legal law library that they're able to go to, and the ability and the education to do legal research and things of that nature.
No, and I think one of the things we've tried to do on the blog is we realize the importance of linking to briefs. And so we have, one of the things that we've done throughout our time is trying to give not only the underlying opinions, but whether it be links to oral argument or briefing, super important. And we think that really helps, especially, the government has access to all kinds of briefs and information, much harder for taxpayers, especially underrepresented taxpayers. So who don't, may not have the access to research, although it's been nice for from tax notes to give access to clinicians, but this is the kind of thing we've thought about, and we've tried to do in our posts, provide more than just kind of the bare bones opinion, give the context and underlying documentation.
Absolutely. Well, in our final 2 minutes, anything that's top of mind? Is there going to be the next hot topic to be covered on procedurally taxing? More on Culp, hopefully.
I'm sure we'll continue to cover the jurisdiction issue as long as it exists. It'd be nice to say that we can stop covering it in the next short while, but I expect each piece of the tax court's jurisdiction basically has to be handled separately. So if Culp were magically tomorrow to be determined to be the law of the land, there'd still be several other jurisdictional aspects of the tax court that would have to be decided. There was briefed and waiting for an opinion the jurisdictional issue with respect to innocent spouse. There would be one with respect to interest. All the different places, all the different ways you can get a tax court. It may be that we never get to a uniform determination of what's jurisdictional and what's not, unless Congress were to step in, and that might be a nice thing, particularly if Congress stepped in and said that none of the bases in the tax court are jurisdictional. But absent congressional action, this issue could go on for quite some time because of all the different areas of tax court jurisdiction that exist.
So we could have probably another 90 posts on this issue. and I think I went back and I've probably written about close to 50 posts on the relationship of the APA and various issues of tax procedure, and that's a really hot issue and something that I know your reporters and have covered extensively as well, and that's something that there's a lot of uncertainty, just as there's uncertainty in the Culp issue. There's lots of nuance to that, and that's something that again we've been working on pretty extensively, both in the blog and in the underlying treatise, right? With the IRS practice and procedure treatise. Yeah. Some of our my colleagues who in that, Greg Armstrong and Rochelle Hodes, who have written for procedurally taxing, are helping and kind of rewrite that material, and that's a really hot issue.
That is a big issue. We'll look forward to that. Well, I want to thank all three of you for coming today. And I want to thank you again for joining the Tax Analyst family and bringing procedurally taxing over. It really is a welcome addition to the other products. in the articles that we have. So thank you all again. Thank you for your time today. And I hope that everyone listening enjoyed and has a wonderful day. Thanks so much.